Greetings students, I hope that you're all doing fine. In this lecture we will discuss standard form contracts. Now this particular topic has nowhere been mentioned as a section in Indian Contract Act of 1872. However, via various judicial pronouncements it has evolved like many other ideas in different laws, and this is the reason why it becomes equally important for us to study it as part of PCSJ examination. So let's begin. So what exactly do we mean when we say standard form contracts? We understand that the law of contract has in recent times come to face a problem which is assuming new and wide dimensions. And the problem has arisen out of the modern large-scale and widespread practice of concluding contracts in standardized forms. The Life Insurance Corporation of India, for example, has to issue thousands of insurance covers every day. Similarly, the Railway Administration of India has to make innumerable contracts of carriage. Now, it would be difficult for such large-scale organizations to draw up a separate contract with every individual. They therefore keep printed forms of contract, and such standardized contracts contain a large number of terms and conditions in fine print which restrict and often exclude liability under the contract. So, in such a scenario, the individual can hardly bargain with the massive organizations, and therefore his only function is to accept the offer whether he likes it or not. So, on that note, we get to the idea of exploitation of weaker party. As you can see on your screen that this, whatever I mentioned right now, this gives a unique opportunity to the giant company to exploit the weakness of the individual by imposing upon him terms which often look like a kind of private legislation, and which may go on to the extent of exempting the company from all liability under the contract. And this is the backdrop under which we study the concept of standard form contracts. Now, when we understand this concept, we must understand that the courts have found it very difficult to come to the rescue of the weaker party, particularly where he has signed the document. Just because this concept has evolved doesn't mean that the courts have always come to the rescue of the weaker party, when actually it's the opposite. In such cases, the courts have been constrained to hold that he will be bound by the document even if he never acquainted himself with its terms. So, this has been understood in the case of L. Estrange versus F. Grocco Limited, whereby Mrs. L signed an agreement without reading it, under which she purchased a cigarette vending machine, and the agreement excluded liability for all kinds of defect in the machine, and the machine turned out to be totally defective. So over here, the court found it as a fact that the supplier had made no effort to bring the sweeping exemption term to the notice of Mrs. L. But even so, and this is important, the court held, where a document containing contractual terms is signed, then, in the absence of fraud or misrepresentation, the party signing it is bound, and it is wholly immaterial whether he has read the document or not. So, the court's observation was based on the implicit idea that the result would have been different if the plaintiff had not signed. So, students, we see over here that in such contracts, the only thing that matters apart from misrepresentation or fraud is that whether the plaintiff has signed the document or not. Now, on that note, seeing the given scenario where such standard form contracts come into picture, a lot of protective devices have been evolved by various cases through courts. So, the individual therefore deserves to be protected against the possibility of exploitation inherent in such contracts, as we have discussed. And following are some of the modes of protection which have been evolved by the courts. And number one, it is reasonable notice, the very important one. So, in the first place, we understand that it is the duty of the person delivering a document to give adequate notice to the offeree of the printed terms and conditions. Where this is not done, the acceptor will not be bound by the terms. And this has been laid by the House of Lords in the landmark judgment of Henderson versus Stevenson. If you would remember, students, in our very first lecture, I had discussed with you this given case law. So you see, this is how the MCQs which come in the examination become really important. If we would be aware of all the options that come in such a question of an MCQ, then we would have a good idea about such case laws. And even when we're writing mains answers and we are not aware of the facts of the case, just because we remembered what the given case resembled, in this case for example Henderson versus Stevenson resembles reasonable notice, so if you were to write an answer on reasonable notice, you could quote this case law and you would be getting decent marks for the same. So under the category of reasonable notice, we see a lot of ideas. First of all is the idea of difference between contractual documents and receipts. So in the application of this principle, the courts have had to distinguish between two kinds of documents, namely contractual documents and mere receipts and vouchers. And the courts in Parker versus Southeastern Railway Corporation have emphasized this distinction, whereby the court held that I think there may be cases in which a paper containing writing is delivered by one party to another in the course of a business transaction, where it would be quite reasonable that the party receiving it should assume that the writing contained in it no condition and should be put in his pocket unread. For instance, if a person driving through a turnpike gate received a ticket upon paying the toll, he might reasonably assume that the object of the ticket was that by producing it, he might be free from paying toll at some other turnpike gate and might put it in his pocket unread. On the other hand, if a person who ships goods to be carried on a voyage by sea receives a bill of lading signed by the master, and this bill of landing, he would plainly be bound by it. Although afterwards in an action against the ship owner for the loss of the good, he might swear that he had never read the bill of landing or that he did not know that it contained the terms of the contract of carriage. But a document is said to be a contractual if it embodies the contract, and that is to say, if the persons to whom it is delivered should know that it is supposed to contain conditions. So this is the major distinction between contractual documents and receipts. Now, on the idea of contract signed by acceptor, we see that where a written contract is signed by the party accepting, he becomes bound by all its terms, whether he has read it or not. And in an ordinary case where an action is brought on a written agreement which is signed by the defendant, the agreement is proved by proving his signature, and in the absence of fraud, it is wholly immaterial that he has not read the agreement and does not know its contents. So that is what the courts have come to mention on this given note, that wherever a contract is signed by the acceptor, it becomes important that it is not material whether he has read the agreement and does not know its contents. And that is when the given case is in the absence of fraud, that is in an ordinary case. Now on the question of notice of unusual terms, it has been held in Inter Photo Picture Library Limited versus Teleto Visual Programs Limited, whereby the defendants and advertising agency required photographs for a 1950s presentation, and the plaintiffs dispatched 47 transparencies with a delivery note which stated that the same were to be returned in 14 days and that a holding fee of £5 each day per day for each transparency would be charged if they were not so returned. Now the defendants here, they did not use the transparencies and instead put them to one side and forgot about them for a further 2 weeks. To their utter and considerable consternation, an invoice arrived for £3,783 holding fee. In this case, the court said that where a condition is particularly onerous or unusual, the party seeking to enforce it has to show that a clear, fair and reasonable effort was made to bring it to the attention of the other party. And the condition in this case was unreasonable and extortionate and had not been sufficiently brought to the defendant's attention. And that is why it did not form part of the contract. So we can see here two distinctions under the category of reasonable notice. One whereby the contract is signed by the acceptor, and one where there is a notice of unusual terms. So when we write such an answer on any topic, for example reasonable notice, we must talk about both the arguments for and against the motion, and then we must conclude with a decent authority which should be the law of the land. Now the second point, the second protective device is that of notice being contemporaneous with contract. So the notice of the term should be given before or at the time of the contract. A subsequent notification will indeed amount to a modification of the original contract and will not bind the other party unless he has assented thereto. And it was seen in Ollie versus Marlborough Court Limited that whereby a man and his wife hired a room in a hotel and paid a week's rent in advance, and when they went up to occupy the room, there was a notice on one of the walls to the effect that the proprietors will not hold themselves responsible for articles lost or stolen unless handed to the managers for safe custody. This was what the notice said. Now their property having been stolen owing to the negligence of the hotel staff, the defendants, they were held to be liable, as the court held that the notice was not a part of the agreement, and very rightly so. So it must be understood that the notice is actually contemporaneous with the contract. Now thirdly, the very third protective device which has been evolved by the courts on this given topic is that of doctrine of fundamental breach. So what do we mean when we say fundamental breach? In general, it sounds like a pretty generalized term, but when we talk about its context in the area of law of contract, then we must understand that this theory of fundamental breach, it is nothing but actually a method of controlling unreasonable consequences of wide and sweeping exemption clauses. That is, where adequate notice of the terms and conditions in a document has been given, the party imposing the conditions may not be able to rely on them if he has committed a breach of the contract, which can be described as fundamental. So on this fundamental we would be talking about further, but before that we must talk about it via case. So an easy illustration is to be found in cases where goods different from those contracted are delivered. For example, in the case of Findlay versus Coldwell, a car was sold on as-is basis and without any warranty or guarantee whatever. Even so, the seller was held liable when 5 days later the engine of the car blew up. So over here in this case we see that it was not a car which was delivered, hence the contract was fundamentally broken. The very matter of the contract, that is car, it was not exactly clear, it was not exactly the car with which the contract was entered into. So it is only natural that the contract was fundamentally broken from always. And on this note, question has been asked in 1991, question 10B in UPPCJ, whereby we had to write short notes on doctrine of fundamental breach. So I hope that after covering this, we would be able to write a decent answer, short note on doctrine of fundamental breach, whereby we can give the introduction as the first para, and then in the body we can talk about this case law, and then another case law which I would be continuing with, and lastly we can conclude the answer with the given with the judgments of the two case laws. So what is a doctrine of fundamental breach? That can be determined by understanding the core of contracts. For example, every contract contains a core or fundamental obligation which must be performed, and if one party fails to perform this fundamental obligation, he will be guilty of a breach of the contract, whether or not any exempting clause has been inserted which purports to protect him. So this may be illustrated with the facts of Davies versus Collins. Over here, the plaintiff entrusted to a dyer and a cleaner a uniform for cleaning. On the docket given to him when he handed over the uniform were the following clauses: whilst every care is exercised in cleaning and dyeing garments, all orders are accepted at owner's risk entirely, and we are unable to hold ourselves responsible for damage, shrinkage, color or defects developed in necessary handling. The proprietor's liability for loss is limited to an amount not exceeding 10 times the cost of cleaning. So, the defendant here sent the uniform to be cleaned by a subcontractor and it was never returned. The plaintiff then claimed the full value of the uniform, and it was held that the mere fact of the particular limitation clause in the contract was sufficient to exclude any right to subcontract the performance of the substance of the contract. Limitation clauses of this kind do not apply where the goods are lost, not within the four corners of the contract, but while something was being done which was outside the terms of the contract altogether, or when loss takes place in the course of some operation which was never contemplated by the contract at all. So we see over here that when the matter is related to the core of contract, it must be seen that this is one of the very important areas where the doctrine of fundamental breach can be invoked, only when it is the core of the contract. Then we see the idea that when there is some provision which is actually a departure from main purpose, that is going against what we just discussed, and it is important to talk about the other side in an answer like I just mentioned. So just like that, when we talk, for example, if a question comes on fundamental breach, we would start the answer by giving the introduction in the first para of this PPT. As you can see in the body, we can talk about the case law of Findlay versus Coldwell and the case law of Davies versus Collins. We can shorten the facts according to our needs, how many words we have to fit it in, and then finally we can conclude the answer by mentioning the departure from main purpose idea, and then talking about the distinction between core of contract and departure from main purpose. So what exactly is departure from main purpose? That we would understand by the case law of Gibbard versus Great Eastern Railway Corporation. In this case, a cycle deposited at a station of the defendant railway company was not in fact taken to the cloakroom, but was left in the booking hall itself, and from there it was stolen. So the company was held to be protected by the clause in the ticket which exempted the company from liability. So we see over here that the very distinction in the facts of these two cases helps us understand that when exactly should this fundamental breach exist. Now coming to the fourth protective device, that is the liability in tort. We see that even where an exemption clause is exhaustive enough to exclude all kinds of liability under the contract, it may not exclude liability in tort. It becomes very important to understand that no matter what the contract says, if it is not necessary that it would exclude liability in tort. So it has been held in White versus John Warwick and Corporation Limited that the plaintiff hired a cycle from the defendants, and the defendants agreed to maintain the cycle in working order, and a clause in the agreement provided, nothing is in this agreement shall render the owners liable for any personal injuries. So we see it is kind of a sweeping statement. But while the plaintiff was riding the cycle, the saddle tilted forward and he was thrown and injured. Now it was held, and it is important that you note this down, that although the clause exempted the defendants, even if they were negligent, from their liability in contract, it did not exempt them from liability in negligence. So it becomes very important to understand that law of contract and law of torts are two different laws, and one cannot guide the terms of another. Now the fifth protective device, that are unreasonable terms. So another mode of protection is to exclude unreasonable terms from the contract. And how is a term unreasonable? A term is unreasonable if it would defeat the very purpose of the contract, or it is repugnant to public policy. So in Lily White versus Munuswamy, a laundry receipt contained a condition that a customer would be entitled to claim only 15% of the market price or value of the article in case of loss. And the plaintiff's new sari was lost. So the court observed, certainly, the conditions printed on the reverse of a bill may govern or modify any simple contract, subject to the obligation on the part of the businessman to perform the process properly and to return the article safe and intact. But if a contract is imposed which is in flagrant infringement of the law relating to negligence, the court will not enforce such a term which is not in the interest of the public. So it becomes important to understand the crux of this judgment, student, interest of the public, about services that you market, and which is not in accordance with public policy, interest of the public and public policy. And there is certainly justification for the observation that this, that is the enforcement of the condition, may well be putting a premium upon the abstraction of clothes which may be committed by an employee of the firm, intent on private gain, though the firm itself may be blameless with regard to the actual loss. So this becomes a very important authority when we talk about unreasonable terms in any contract. And I want you to remember this case law in the times to come, because it would become important for the same. Now, lastly, I would be talking about under this category, that is the fifth protective device, there are removal clauses in many contracts of employment. So, a term in a contract of employment being offered by a government corporation providing for the removal of a permanent employee without inquiry has been regarded by the Supreme Court to be unreasonable. There are many cases, many practical cases are asked in the mains answers many a time, and many of them are related to government contracts. So for such matters, it becomes important to cover this given provision. And in Sri Lekha Vidyarthi versus State of Uttar Pradesh, the Supreme Court has gone further still by laying down that in all its affairs, including economic and contractual matters, the state and its instrumentalities have to observe the mandate of Article 14 of the Constitution and offer equal opportunities and make a fair and reasonable selection of the party, including the selection of a government district council on whom benefits of a government contract are going to be conferred. Now lastly, the sixth protective device which has been evolved by the courts is that of exemption clauses and third parties. So one of the basic principles of the law of contract is that a contract is a contract only between the parties to it, and no third party can either enjoy any rights or suffer any liability under it. So this should apply to standard form contracts also. The effect would be that where goods are supplied or services rendered under a contract which exempts the supplier from liability and the third party is injured by the use of them, the supplier is liable to him notwithstanding that he has purchased his exemption from the other party to the contract. If, for example, a contractor agrees to maintain and repair a lift in certain premises under contract with the owner who exempts him from liability, that exemption would be of no avail to the contractor against a person who is injured owing to bad repairs. I hope that you understand this example. A contractor agrees to maintain and repair a lift in certain premises under contract with the owner who exempts him from liability. That exemption would be of no avail to the contractor against a person who is injured owing to bad repairs. So you can understand that this actually is going with the logic of exploitation of the weaker party, if you think about it. But the reasoning for this provision is that if this were not so, the life and security of millions of people would be in the hands of the two parties to a contract. So they would then make law not only for themselves but also legislate for countless others. Obviously, therefore, in Hazeldine versus C.A. Daw and Son Limited, the above mentioned lift case, the defendants were held liable for the tort of negligence. So one of the basic principles of the law of contract is that a contract is a contract only between the parties to it, and no third party can either enjoy any rights or suffer any liability under it. This is what we call the privity to contract. So this should apply to standard form contracts also. The effect would be that where goods are supplied or services rendered under a contract which exempts the supplier from liability and a third party is injured by the use of them, the supplier is liable to him, notwithstanding that he has purchased his exemption from the other party to the contract. And that is very important. If, for example, a contractor agrees to maintain and repair a lift in certain premises under contract with the owner who exempts him from liability, over here, that exemption would be of no avail to the contractor against a person who is injured owing to bad repairs. So, earlier we were talking about the exploitation of the weaker party, and this is why this has been considered to be one of the protective devices. Because if it were not so, then if we think about it logically, the life and security of millions of people would be in the hands of the two parties to a contract. And they would then make law not only for themselves but also legislate for countless others, and this is simply unacceptable. So the above example that I have mentioned to you, it actually comes from the case law of Hazeldine versus C.A. Daw and Son Limited, in which the defendants were held liable for the tort of negligence, and in this case the learned Judge Goddard reminded the contractor has the duty to the third party which does not arise out of contract but independently of it. So students, that covers the third lecture of the certification course on law of contracts, as a part of which I have discussed with you standard form contracts thoroughly. I hope that you will be able to solve any and all the questions coming from the same topic in your given examination. Thank you. Till we see each other again.